Please be seated. Good morning. Welcome to the Texas Supreme Court. We'll hear three cases this morning. The first is 230634, First Sabrepoint Capital Management and others versus Farmland Partners from Dallas County and the Fifth Court of Appeals. The second case is 230875, Thompson versus Landry from Chambers County and the First Court of Appeals. And finally, 240081, Enrique Carlson, an original petition for writ of mandamus. The court has allotted 20 minutes for each side in each of these cases. We will take a short break between the arguments, which can be watched live online this morning and will be available on the court's website later today. We're ready for argument in 230634, First Sabrepoint Capital Management and others versus Farmland Partners.
May it please the court, Mr. Cesari will present argument for the petitioners. Petitioners have reserved 5 minutes for a vote.
Good morning, Mr. Chief Justice, and may it please the court. I think at bottom, this case boils down to a couple of very intuitive and basic principles with some big implications for Texas jurisprudence. The first of these is that almost invariably, the district courts of Texas should have the authority to reconsider their previous rulings. We want judges to be able to determine when they're wrong, to be able to correct their errors, and avoid it having to do any kind of appellate proceedings to fix them. So,
can the error be corrected through other procedural vehicles that don't have a timing deadline, with the idea that a docket control order sets reasonable expectations about the conduct of a case, and the TCPA motion is something that is intended to be a vehicle for early dismissal?
Well, we think that there are, I think, a variety of mechanisms that you can do to control dockets. I think that.
Right, but if it's pure error correction, a trial judge can grant summary judgment, could maybe even perhaps convert with notice to the parties a TCPA motion. What is the reason that we should ignore the statutory deadline for early dismissal and permit multiple iterations of TCPA motions throughout the course of the suit?
Well, I think no one's suggesting that we should ignore the 30-day deadline. It is mandatory. It does direct the district court to do something, but I think that the consequences of the court's failure to do something should never fall on the party who's supposed to be protected by the statutory deadline. The 30-day deadline exists pretty much entirely to make sure that district courts don't ignore a TCPA motion, just kind of carry it with the case and allow things to go on for months and months and months. That's why the 30-day deadline exists. That's why it imposes
the consequence on that side is that it's denied by operation of law, and then a party can, at that point, bring an interlocutory appeal.
That's right, but forcing a party to go up on appeal and maybe all the way up to this court to come back down to get relief that a trial court was already planning to give them anyways, and in this case would have been 3 days late. That should not be. That doesn't seem like that fulfills the purposes of the statute. It puts all of the consequences in exactly the wrong place. It doesn't encourage trial courts to move any faster, and I think most importantly, as Panchakarla said, that's just not the kind of thing that the legislature had in mind when it created this 30-day deadline in the TCPA.
Is it the kind of thing that the legislature had in mind for a case to go? I realize this is not your case, but it seems like the rule that you're advocating, you could have a case go on for 2 or 3 years, and one of these is denied by operation of the TCPA motions, denied by operation of law. The party who filed it decides not to take it up for whatever reason on an interlocutory appeal. But you've got a big hammer hanging out there on attorney's fees that you don't have with a motion for summary judgment. And so what suggests that, 3 or 4 years later, when they find all the discoveries done and everybody's finished with their motions for summary judgment in a big case, that the legislature intended the TCPA motion to still be hanging out there and have a possibility of it being granted, even though the whole matter's teed up on summary judgment?
Well, I think seems like the major consequence you're worrying about there is the hammer of attorney's fees, and I mean,
Well, why, I don't see any indication in the statute that TCPA motions are sort of evergreen in the way that you're suggesting.
Well, I think that if the court had denied the TCPA motion before it could have reconsidered that motion at any point during the case, I think Pancho Carlo is pretty clear that that's exactly what that you anticipated when you wrote Pancho Carlo, is that it doesn't, you can reconsider those orders at any point in time so long as the court's got plenary authority over the case. So I think that is true. I don't think that has a consequence in terms of resolving the merits of the case all that much, because that could also happen on summary judgment. I would assume that a TCPA motion would be, or a reconsideration motion would follow with the motion for summary judgment. So it doesn't seem to be that much different from summary judgment, except for the addition of the potential for attorney's fees. But I would assume that the party's obligation to segregate the fees incurred in the TCPA motion at the very beginning of the case wouldn't really carry through to the discovery that happens after that motion's been fully briefed and heard, any more so than they already overlapped already.
In this case, were both motions based solely on the ground of collateral estoppel?
Both motions,
The motion to dismiss under the TCPA and I think previously filed, right? Wasn't the motion for summary judgment filed first?
yes, that's right.
Okay, so you filed a motion for summary judgment based solely on collateral estoppel, and then while that was pending, you filed a motion to dismiss under the TCPA, also based solely on collateral estoppel?
That's correct. We thought that they'd both been resolved.
You have data about how often someone moves to dismiss under the TCPA, is denied by operation of the law, and they don't bring an interlocutory appeal within the statutory period?
I did not prepare those for you. I'm sorry.
I share Justice Busby's concern about the idea that you could go for several years and then a judge could, I suppose, it seems like reading narrower and narrower with each thing. I would not grant summary judgment. I think it was a fact question, but I've decided 2 years later, TCPA, you win on that. Doesn't seem like what the TCPA was intended for. But in this case, I take it that, at least it's plausible, that if the period to bring an appeal had come near its end without the judge reconsidering, well, you would have had the opportunity to bring that interlocutory appeal.
I suppose that there's the potential that could happen. And I suppose that is the risk that you raise. I don't see a particular need for that when the court could grant for summary judgment or grant judgment as a matter of law sua sponte if it felt comfortable doing so. The TCPA's resolution doesn't do much more, again, beyond attorney's fees, and the consequences going the other way seem to be something more to worry about, and more what the legislature was worrying about in creating the 30-day deadline.
So I guess what I'm wondering is, do we really only have the thumbs up and the thumbs down option, or would it be possible, and you tell me if you think that we really need to be thumbs up, thumbs down, I'd want to know it, but it seems like it would be potentially reasonable to say that a trial judge has the opportunity to reconsider the denial by operation of law of a TCPA motion within the period in which the interlocutory appeal could be perfected, but after that not, in order to eliminate these concerns. What do you think about that?
I would say, I mean, I've not briefed up this issue and I haven't looked up the law, but it seems to me like there's got to be some principle of laches on the outside. And I don't know where exactly that deadline falls. I think 3 days after the deadline falls with any conception of it. But it does seem to me like the period in which you would get the chance to appeal is some reasonable period by which at least they ought to have that amount of time to do a reconsideration motion. They clearly have plenary power. The very idea of giving that amount of length of time to take an appeal practically invites the opportunity for the trial court to reconsider it within that period of time. You might read.
There's at least nothing terribly unfair about saying, well, if you don't even bother to appeal it after you made the motion and it was denied without even the court telling you why, well, maybe maybe you've lost your chance and we're gonna move on with it.
I mean-
That doesn't seem unfair, at least, right?
It doesn't seem unfair, but it does seem to be that you're starting to stray from what Pancho Carla said about these deadlines, and also starting to stray from the lessons that we should draw from the legislature from them. I mean, there are no real hard deadlines here. The legislature hasn't seen fit to say you can't reconsider these things. It plainly contemplates the ability to do reconsideration, because it doesn't impose any
Your case is
consequences.
one in which the rule that I've hypothesized, and I'm not taking a position on it right now, just hypothesizing it. We could reserve that possibility without adopting it and still rule for you on the TCPA question, I take it.
I think, again, if there's some kind of period after it, I can't imagine we'd fall outside that period by being 3 days late. And at the very least, it would be the minimum, the amount of time it would take to do an appeal. So we certainly don't have any objection for you to do that. We don't know that that's completely necessary to do.
If we rule for you on the TCPA question, do we have to reach the summary judgment question, given the
Yes.
standards are different? You think we do have to?
Sorry, yes, I think you do. I mean, they certainly don't resolve each other.
Well, the opposite doesn't seem to be true. I mean, if you filed both motions on the same ground, collateral estoppel, trial court granted both motions. Court of Appeals reversed as to collateral estoppel, saying that collateral estoppel doesn't apply, and therefore you were not entitled to summary judgment. And if that's true, if we agreed with that, if we agree with the Court of Appeals that you were not entitled to summary judgment based on collateral estoppel, then it would necessarily be true that you were also not entitled to a motion to dismissal under the TCPA. And it seems to me that would just moot the whole TCPA issue that's before us.
I don't think that that is the case, because we don't really know what the appeal that was dismissed was going to raise, whether they were going to raise the identity of that, or the only challenge.
Well, the only thing you could
reasonableness
have,
of fee.
I mean, you were, if it was dismissed based solely on collateral estoppel, the only argument on appeal would have been that collateral estoppel didn't apply.
That just seems to me to be a hypothetical argument, and we
What
don't
other
really know.
argument could they appeal on?
And they've also lost their right to revive that appeal because they didn't cross petition to this court when that appeal was dismissed. So I don't think that we can take away on a hypothetical ground on an appeal that wasn't ever raised. It's something that was raised in a completely different question before the court.
Would you say that if the losing party in the TCPA ruling appeals immediately, that would cut off the district court's ability to reconsider?
I think the court was pretty clear in Pancho Carla that that is exactly what would happen. Once, and it's a dual consequence. Once they've appealed the failure to rule on the order, and you have the denial by operation of law, then the jurisdiction over that order has gone to the Court of Appeals. And it's
Well, and
left.
actually, all proceedings are stayed, right?
And that's the second consequence, is that proceedings are stayed, so you're not going to be doing much of anything on the case. I would like to briefly turn to the arguments of res judicata, and I really only wanted to make sure I made one point before you here today on that question. There's been a lot of talk in the respondent's brief about, well, there was some evidence that we weren't able to get in front of the Colorado District Court, and I want to give the court absolute assurance that is not the case, and I would commend to the court our summary judgment motion at pages 195 and 194 and 195. We talk about the fact that they had 8,000 documents, they had 18 depositions, and they had document requests, and we literally paraphrase, we put out those document requests in the motion for summary judgment, in which they were.
So if we agree with you that jurisdictional findings can support a collateral estoppel defense, what finding, I think the contention is that even if that's the case, the findings made in Colorado were either not fully and fairly litigated or not germane to the issues that are brought in this suit. And what's your response to those?
So as I was saying, they had an absolute full and fair.
I understand that there may have been materials filed, but the idea is, a finding has to be fully and fairly litigated and essential to the judgment.
Yes.
So
fully and-
talk about those
it's a
and
full and
why the
fair-
jurisdictional
sorry.
findings were litigated and essential.
So the fullness and fairness goes to an opportunity. It's not a perfect opportunity to get every single piece of evidence that you would like. The obligations that this court said in, I want to get the case for you. Well, the court said, and we said, again, I'd commend to you 195 of our motion, says you need three things for it to be fully and fairly litigated.
But let me
It's
ask
gotta-
you, my question is related to Justice Bland's, and that is that, when you, when findings are made as to a jurisdictional issue, that same finding on another issue may or may not be fairly applied, right?
No, I don't think that that's the case. I think if it's been fairly litigated in one consequence, once we've established that the sky is blue, when we know that, then.
Well,
no,
maybe if it's as easy as that, is the light red or green, but we hear all kinds of things, and I can envision different situations where it may depend upon what the merits of whatever we are deciding.
I can't imagine that set of circumstances. I certainly don't think that we're in those set of circumstances here today. I mean, we're talking about they took the very same jurisdictional allegations from Colorado and used them as the basis of their claims in that case, and the same basis of their claims in this case. And we think that, as we've outlined in our brief, that they go all the way to all of the claims against all of the parties. They map on completely. So maybe, I suppose, but I don't know that, I don't really know once we establish a particular fact that it really ought to change that much in a different context.
Any further questions?
Just one, you, in the Colorado case, had a federal district judge that was looking at agency, for example, under Colorado law for personal jurisdiction purpose. I wonder if we're getting even further away. Is that the same legal principle that would apply in the Texas litigation, or is that moving us away from being able to apply collateral estoppel?
I don't want to give you too long an answer, but I would like to give you a full answer if that's okay with the court. I think the part of it is, number one, you have factual conclusions and you also got legal conclusions. I think you can set aside completely the legal conclusions if you wanted to and say, well, don't worry about what the law of agency in Colorado is. Let's just talk about the factual reasons there's no agency. There's no agency because he's an independent contractor and you have no right to control him. Well, those factual conclusions map onto the claims of this case, regardless of whether you make any legal conclusions about agency or not. But the law of agency in Colorado and the law of agency in Texas are exactly the same. They use the same restatement principles. We've cited them in our brief. So I don't think that there's any real concern that you should have, at least about this case, about using them as preclusive. That may be different in different cases.
Any further questions? Thank you, Mr. Cesare. We will hear from the respondent.
May it please the court, Mr. Bennett will present argument for the respondent.
May it please the court. Mr. Chief Justice, may it please the court. Sabrepoint's atextual and strained reading of the TCPA and its vast expansion of the collateral estoppel doctrine cannot support the trial court's judgment. And the Court of Appeals was correct in reversing that judgment and remanding it for a full trial on the merits. Starting first with the TCPA motion, I think we've already heard my friend concede that his position is too extreme and that latches may have to come into play. And very much for the reason that Justice Busby, you pointed out, that attorney's fees are very much in play here. If you read 2709 of the
Counselor, I
TCPA...
wouldn't want to be atextual, and section 27.009A1 does say shall award reasonable attorney's fees, but 27.005 also says must decide, and yet here we are. But doesn't 27.009A1 also say shall award reasonable attorney's fees? Why would you need latches when reasonableness is textually built right into the decision that the trial court's supposed to make?
Well, I think the latches point is more about what happens when you don't appeal. So how can the trial court, if the TCPA motion is denied by operation of law, several months go by, we have a case in the record, Long is that case. Several months go by where no ruling is entered, no appeal is taken either of the TCPA motion, and then suddenly the court reverses its denial by operation of law and enters an order granting the TCPA motion. my friend's point was, well, at some point latches may apply and preclude the trial court from doing that, but how would the trial court know that when there's nothing in the statute to say that when the latches point kicks in? And latches, it's an odd concession because latches binds litigants, not courts.
But it wouldn't really be latches, would it? I mean, it's a textually based reasonableness requirement, and our court can give guidance to the inferior courts in this state and could say, don't let counsel pound the file. If you miss the deadline a little bit, no problem. If it goes on for a long time and it's past the point to appeal or something like that, don't count any of those time entries. Don't do a lodestar or anything like that. But just realize, wish I would have realized this sooner, and, your firm isn't going to get new office space from this, but that's still a reasonableness determination that's grounded in the text of the TCPA, isn't it?
But not necessarily. If you look at 2709A, what it says is not the fees incurred in pursuing the motion, it's in defending the legal action. So if I am the defendant in a TCPA case, and 7 months later, after it's been denied by operation of law and no appeal is taken, I have a textual hook right in 2709A to go after all of my fees spent in defense of the legal action. That's the plain language of that
Sure,
provision.
nobody could blame you for trying, but if we're talking about, we're here because the district court already missed a must and was a little bit late, and now we're trying to make sure that we announce decision that will guide future cases to make sure that these things don't get abused. And so, yes, they should follow the must that the legislature gave them, should follow the deadline, and then when they shall award attorney's fees, they shall make sure that they are reasonable, and they shall not allow the bar to pound the file.
Certainly the court may do that, I suppose, but there are at least three other textual hooks that would mitigate or militate against that finding. That's why all the courts of appeals to date, even after Poncha Carla, have reached the conclusion that we've advanced in our brief on the merits, which is the mandatory date is mandatory because it provides a consequence. I want to point out two cases. One is a decision from this court in Morath. I think the friend of court that filed on behalf of my friend cited. Morath was an 180-day deadline to comply with a district having a hearing, right? And they tried to use that as grounds to say no penalty at all for compliance, as there is in 2708. But they tried to say that because we didn't hold the hearing, we don't have to do it now. And the court said no. It cited a case, U.S. v. Dolan, in footnote 81 of Morath. And Dolan cites a canon of construction that I think is worth the court's time, having cited Dolan already, that when a mandatory provision is provided, if it provides a time for compliance without any language denying performance after a specified time, if it lacks that language, it's directory. Of course, if it contains it, then it's mandatory, and mandatory means mandatory. And I think, Justice Bland, your point...
Nobody's disputing that, are they? I mean, everybody says, yeah, it's denied by operation of the law. So it's not only just mandatory, it happens whether the judge wants to do it or not. So we've taken the mandatory directory thing out of the judge's hands.
Correct. And so in this exercise of statutory construction, the question is, once we're outside that period, what may, if anything, the trial court do to revive a motion that's been denied by operation of law? And if this court decides that 30 days doesn't really mean 30 days, then we're into this outside of what the legislature intended. And at least
I don't understand that either. Of course 30 days means 30 days. Nobody's disputing that it is denied after 30 days. The question is whether or not that standard, that time, which is not truly unique in this one context, can be reconsidered. Whether or not something different than the usual principle that Texas courts have the chance to think again, at least for a while, is set aside here. And Poncha Carla talked about both in the same voice. It said that the TCPA is silent about a trial court's authority to reconsider either a timely issued ruling granting a TCPA motion to dismiss or a timely order denying such a motion when no interlocutory appeal is pending. I just don't understand why you think that treating the two the same, at least for a while, is ignoring 30 days or disregarding the statute or changing what's mandatory into something that's not. It's normal for courts to have this authority.
Well, I think the operative language that Your Honor just quoted from Poncha Carla is timely. In both of those instances, a timely action by the trial court. The question is what happens if it's untimely, when nothing happens.
By operation of law, though, then, right?
Correct, and that would make any order that comes after the 30-day mandatory period untimely. So the question is what
if the judge actually timely denied it on the last day, you would think that the judge then could reconsider it and grant it later or not?
If the trial court denies on the 30th day a TCPA
10
motion,
minutes before the magic happens and it's by operation of law,
Then
the
it's
trial court denies it.
then it's denied, and the defendant would need to appeal within.
But there's no difference about whether it's timely in that fashion. Your argument is the 30 days means that it's over. It's denied, no reconsideration, no matter what.
I think if we take a step back and look at the TCPA as a whole and construe it as a whole, as the court should, if you look at the provisions as they operate together, what the legislature wanted was balancing out the rights of the movant and the non-movant is for everybody to move with alacrity. The movant to file very quickly, the hearing to be set quickly, and then a decision to be made quickly after the hearing. On that conveyor belt, I think Justice Bland, your point about 2711 is a key one. Once you're on that conveyor belt and the 30-day period has run, there are plenty of other tools that a trial court may use if it felt pressed for time and didn't feel like it could dismiss everything.
Your point is that there is a consequence when denial happens by operation of law. The defendant has the right to appeal. And the question is, by providing the right to appeal as a consequence of denial by operation of law, did it foreclose sort of another look by the trial judge, at least within the time for filing the appeal? And if the trial judge takes another look at it, does that then extend the time for, for the appellate rights, I guess, if it's a partial grant? If it's a final grant, it's a final judgment. So I think the question is whether, the right of appeal is what's granted, or if there could be something more that the trial judge could do.
There is something more that the trial judge can do, and that is, I think Your Honor pointed it out, the trial judge can control his or her docket, can say, look, I denied it by operation of law, but I'm going to set a phased case. I wasn't sure about these couple of issues. We're going to phase the case to focus on this and conduct discovery in this way. Under summary judgment, you can convert the TCPA briefing to summary judgment, require a different structuring of the case under its inherent powers with the docket control order. But once it's off the conveyor belt for the TCPA, it's off the conveyor belt. The defendant
Does it matter that there's limited grants of opportunities to extend the time frames within the TCPA in certain instances?
I think it does matter for those particular instances. So, for example, the court has to have set a hearing within so much time. And if a litigant finds itself in a trial court who won't set the hearing because there's no penalty of compliance in that particular instance under 2703, mandamus relief may lie if you can't ever get a hearing because the trial court won't set one. But here the legislature spoke specifically about a specific consequence if the trial court doesn't rule within 30 days of the hearing. And that consequence should be held to apply in exactly the way the courts of appeals, all of them who have addressed the question, have applied it.
If we agree with you that collateral estoppel does not apply, is the TCPA issue here moot?
I think it is as on the briefs as they've come to you. I will say just a clarifying point of the record. The first volume of the clerk's record, page 564, is the TCPA motion. It never addressed initially collateral estoppel. It was more or less a no evidence summary judgment motion under TCPA garb.
Okay, so the ground for dismissal under the TCPA was not collateral estoppel?
Collateral estoppel came in later under the TCPA. That's at the second volume of the clerk's record, page 2630. They filed a supplement saying, oh yeah, and by the way, you can grant us relief under the TCPA on collateral estoppel too. But the first actual motion never raised collateral estoppel. That's, again, the first volume of the clerk's record on page 564. And the reason that it matters now is we raised this in the petition for review stage, but in their reply, they've not asked for any sort of remand to address the larger set of TCPA issues. In fact, they disclaimed it. They said a remand would be pointless. They're not asking for further review on all of the other reasons that we initially appealed until the Court of Appeals pre-terminated the issues. So I don't know why the court would give them relief they're not seeking. So if
They filed a motion for summary judgment that was based solely on collateral estoppel.
Correct.
Then later, they filed a TCPA motion to dismiss that was based generically on no evidence.
Yeah, it was.
And then then later, they supplemented the TCPA motion to say also based on collateral estoppel.
Correct.
And then the trial court granted both together.
Correct. After the time had run, the trial court
sure.
entered an order granting everything.
Yeah, what I'm thinking, I mean, if you're in, yeah, if we were to agree that collateral estoppel, with you and the Court of Appeals, that collateral estoppel does not apply, then it was error to grant the motion for summary judgment, and it was error to grant the supplemental motion to dismiss. And then there's this lingering question about whether there was some other ground in the original motion to dismiss that could still have justified dismissal. And your point is, yeah, but they haven't sought relief on appeal on that.
Correct. They didn't, when they petitioned in this court and in their reply, they definitively disclaim any desire for a remand to address. They say it would be pointless. What would be the point of a purposeless remand?
And so what's your position then if we were just imagine to agree that the TCPA order was not void? What's your position about whether this court ought to reach the collateral estoppel issue itself or handle that by a remand?
If the court...
or remand the TCPA issue to be addressed on the merits by the Court of Appeals?
If the court disagrees with us on the TCPA issue, as the briefing has arrived here, but agrees with us on the collateral estoppel issue, that's it. It should go back to the trial court for a trial on the merits. So if we're right about collateral estoppel, that they failed to meet their burden...
But do we have to address collateral estoppel? I mean, they are distinct, aren't they? I mean, the standards are different, and so if we rewind the clock and say, no, the TCPA motion should proceed, I guess the question is it essential that we address collateral estoppel, or can we just remand on the TCPA and then let the case play out?
I think the most efficient thing would be to address collateral estoppel because it comes up in both motions, right? Both the single issue summary judgment motion and the TCPA motion were collateral estoppel was relied on pretty heavily. In fact, if you read the reporter's record, the hearing on the TCPA motion focused almost exclusively on their part for purposes of collateral estoppel. So
if the trial court in Texas were to instruct the jury as to the finding of the court in Colorado that Sabrepoint was not involved in the allegedly defamatory article, do you have a claim?
we do.
Even if there's a finding that there was no involvement in the article?
Yeah, so we would, under bases of liability that we've asserted that are independent of even involvement, which would be aiding and abetting, for example, under Colorado law that we've asserted. And here's why that would be the case. Even if you're not, I'm going to spin back to involvement and then just generally collateral estoppel after I provide this answer, but...
Involvement would include aiding and abetting, wouldn't it?
No, because if you know somebody is going to engage in the kind of thing that, or you have substantial reason to think it's foreseeable that they'll do this, and the Colorado court definitively said that in its order. It was at least foreseeable that Matthews would do what he did. When you give him substantial assistance under Colorado law, even Texas law, for aiding and abetting, the tort that is committed as a result of that substantial assistance can be attributed to Sabrepoint. Now, involvement is a tricky question because...
But if it's an intentional tort, the aiding and abetting has to be intentional too. It can't be simply negligent.
Correct. If it's an intentional tort, but we have not...
So if a court has found there was no involvement, meaning no intentional participation, how do you get around that finding for a claim?
So two answers. One, depending on what the meaning of involvement is, and I think we have to contextualize that in what the court's order actually was, but getting to the hypothetical that you've provided, if there's an independent basis setting aside whether they were involved in the drafting of the article, if they participated in providing substantial assistance to Matthews, they knew Matthews was doing these kinds of things, and to be clear on that, The record is that Sabrepoint and Matthews 6 different times bet short on stock and then published articles like these and watched the stock drop. It wasn't just one time, it was 6 times. And in fact, in our view, based on the evidence, and we argue this below, all 6 of those times is 100% of the times that they work together. So if it's not involvement in the article itself, it's they know enough about Matthews, having worked with him enough to know that when he takes short and they take short, he's going to drop an article. That's the argument, and the assistance that they gave him. They fed him information, the FBI slide deck that the court mentions.
Right, I hear all that, and
Right.
it sounds like the Colorado court rejected some of that at least.
Well, and that gets back to what does involvement mean. If you look at pages 2 to 3 of tab 1 to the merits brief, which is where the court lines out the facts, there's involvement there. There's no doubt that there's involvement between Sabrepoint and Matthews. The question is involvement for the only question that the court in Colorado was addressing was it involvement for purposes of personal jurisdiction? Under that kind of idea, was it involvement that pointed conduct at Colorado and therefore could be preclusive later?
So with regard to your collateral estoppel argument, just want to make sure I understand it. You're basically saying, number one, the fact findings were not fully and fairly litigated. Number two, even if they were, they're only findings that go to purposeful availment in Colorado, not to the extent of involvement in the wrongful conduct.
That's exactly
Is
right.
that what you're saying? So it's two alternative arguments there.
Correct. And the reason for that is twofold. One, the Colorado order had a purpose, which was to deny personal jurisdiction. You can't sue these particular individuals and companies in Colorado. Go sue them in Texas is the implicit grant that the trial court gave in Colorado.
But if the reason for that was because they had no involvement, I mean, yes, it's true, the end result is a personal jurisdiction finding, but the factual predicate for it is something that surely can be relevant to many other things besides personal jurisdiction, because you can find a lack of personal jurisdiction for things that have nothing to do with the merits, but these sure seem to.
So two answers to that. One, Old Republic title from this court announces just a general background principle of collateral estoppel law, which is personal jurisdiction decisions don't decide the merits of anything. A court that disclaims the authority to adjudicate facts, which is what the Colorado court did, can't adjudicate facts generally. It can only adjudicate issues that are implicated in the personal jurisdiction decision. That's why if you read the cases they cite and support, Unity House, Montesantos, all of them, they're all mixed questions of law and fact that were bound up in the decision that personal jurisdiction was lacking. That is not what involvement is. Involvement is not a mixed question of law and fact about anything. It's just a pure issue of fact. That only lies with the trier of fact, and the Colorado court told everyone it's not the trier of fact in this case. So if it isn't the trier...
They say that the preclusive effect of a federal court's ruling on state court litigation is a question of federal law. Do you agree with that?
Yes, because the judgment came from federal court. But in closing, the court should affirm the Court of Appeals judgment because the TCPA motion was void and the collateral estoppel grant was erroneous. Thank you.
Any further questions? Thank you, counsel. Mr. Cesare, you have 5 minutes.
Thank you, Mr. Chief Justice. I wanted to start by talking a little bit about what happens if there's any kind of disposition on the TCPA motion with regard to the collateral estoppel motion. We still don't think there's any cause for any kind of remand in this case. Their appeal was dismissed. They did not challenge the dismissal of their appeal. They should have filed a conditional cross petition. They did not. There's no appeal left. We don't know whether there would have been, what the grounds for appeal would have been, so we can't assume them, and we certainly can't grant them. Moreover, I think I'm hearing my counsel, as he corrected the record, concede that even resolving the collateral estoppel issue will not moot the TCPA issue because there's also the question of whether or not it might have been correct on the merits, on the evidence presented in the Court of Appeals without regard to collateral estoppel. So there's really no grounds for the court to try and resolve the TCPA issue in any other way other than to grant us, to render judgment and grant us our fees. On the issues
I
of.
want to ask you about the question of whether the preclusive effect of federal court's action on state court litigation is a question of federal law or state law. And it strikes me there's a strong argument to be made that it ought to be a question of state law, that it ought to be for the state courts to decide what can and can't be litigated in their courts. But I take it that we've said it's a question of federal law.
You have.
And I wonder if you have any thoughts on, notwithstanding that precedent, just theoretically, which of those two options makes more sense?
I mean, the court in Cisco said federal and state collateral estoppel principles are basically the same. I don't think that this court has ever specifically resolved the question of whether or not a jurisdictional holding would resolve the merits in another case. But I mean, I don't see any reason why there would be any daylight between the two kinds of actions. And I also wanted to step back and we need to go back to 1L a little bit and kind of distinguish between res judicata and collateral estoppel. In deciding a jurisdictional motion, a federal court cannot resolve the merits. That is not controversial, but it has nothing to do with collateral estoppel. Because even a court saying we lack jurisdiction has the authority to make that determination, they have the jurisdiction to establish their jurisdiction. And when they do that, they have that gives the findings that they make, whether they're legal or factual, in the course of determining their jurisdiction, gives them full preclusive effect. There's no levels of preclusive effect. There's no distinguishment between legal issues or factual issues, and that some travel more than others. I also wanted to emphasize, we've talked a lot about involvement and how involvement matters. And involvement does matter because the court credited the testimony of our officers that we didn't know an article was going to be written. We didn't anticipate that an article was going to be written. So I think the involvement findings do suggest that there is no claim for anything less than intentional torts. Moreover, as the respondent has completely ignored throughout this case, there's also a separate finding that Mr. Matthews was an independent contractor and that we had no right to control him. So what he did on his own time, using his own materials and his own resources, is something that we have no duty to control and we can't be held liable for, even if we might have anticipated. So this entire idea that, concepts of more foreseeability might have mattered, that's not going to save any of their claims against any of the parties.
Going back to the TCPA timing question for a second, if a trial court were to deny a TCPA motion with an express ruling, and then later decided to reconsider that, and so pulled that down, and then looked at it again and denied it again, can there be an interlocutory appeal?
My understanding is that the timing of the appeal, and I've not anticipated this question, so forgive me if I botch it, but mine is that it is pegged to the denial by operation of law, or the denial. You're effectively kind of asking whether it's a second TCPA motion.
Well, it seems like the answer ought to be the same to that question as to the question that you brought, right?
I mean, absent some textual indicator otherwise, I would think so. But
we have a lot of cases that say you can't generally reset the timetable. I think that say you can't generally reset the timetable on interlocutory appeals by basically re-entering the same order.
I think that might have been the case, but for another context. But I think that the TCPA context is unique just by virtue of the fact that there's this a denial by operation of law, and you're reconsidering it. And so I honestly don't know the answer to that question. I wanted to
Any further questions? Thank you, counsel.
Okay, thank you.
The case is submitted and the court will take a brief recess.
All rise.